Wisconsin already had plenty to say about Xavier Lucas transferring to Miami. Let's get the other side of it. Lucas's attorney is going to join us here on Locked On Canes.
You are Locked On Canes, your daily podcast on the Miami Hurricanes, part of the Locked On Podcast Network, your team every day.
Happy Monday, if there is such a thing. I am Alex Dono, University of Miami alumnus, co-host of Locked On ACC, and writer for Canes County at Rivals. And thank you so much to the Everydayers for making Locked On Canes your first listen and your first watch today. We're available free wherever you get your podcasts. We're free on YouTube. We're part of the Locked On Podcast Network, your team every day. Today's episode is brought to you by FanDuel. From the first whistle to the final drive, FanDuel makes the NFL playoffs even more exciting. Right now, new customers can bet $5 and get $300 in bonus bets if you win your first bet. Visit FanDuel.com to get started. All right, we're going to break down the inside story of Xavier Lucas's transfer from Wisconsin to Miami and responses to that Wisconsin statement that they released over the weekend and the Big Ten statement, as well as we're going to be talking not only with Darren Heitner, founder of Heitner Legal, who is representing Xavier Lucas. We're also going to talk with the truth teller. We're getting him out of retirement again. So for reference, because we're going to be responding to a lot of this stuff that Wisconsin put out there in their Saturday evening statement, let me read the statement for you and we'll break it down with Mr. Heitner. Wisconsin on Lucas transferring to Miami, despite them never putting him in the transfer portal. They say, "We are disappointed that Xavier Lucas has chosen to withdraw from the University of Wisconsin. He has been a valued member of our football program. We were looking forward to helping him continue to grow as a student, a person, and a football player." On December 2nd, 2024, Xavier and Wisconsin Athletics entered into a binding 2-year NIL agreement reflecting his strong commitment to continuing with the Wisconsin football program. We understand that he also executed a separate agreement with the Varsity Collective. His agreement with Wisconsin Athletics included substantial financial compensation for Xavier. Under the terms of the agreement between Xavier and Wisconsin Athletics, it remains in effect and enforceable, they say. They continue. Badger student athletes who have signed these agreements expect Wisconsin Athletics to honor the terms. In turn, Wisconsin Athletics relies on the student athlete representations in signing these agreements that they will do the same. A request to enter the transfer portal after entering into such an agreement is inconsistent with the representations and the mutual understanding of the agreement and explains, they say, the reason for not processing a transfer portal request under these circumstances. Under the transfer provision used by Xavier this past week, any contact between a student athlete enrolled at one institution and the football program to which they are transferring is prohibited per NCAA rules. We have credible information indicating impermissible contact between Xavier and University of Miami football program personnel prior to Xavier's request to enter the transfer portal. Direct interference with another institution's committed player and contractual interests is prohibited by NCAA tampering rules and the law. This is another significant moment, they say, in the evolution of college athletics as we move toward a future state that will rely on direct contracting with student athletes. Enforcing the parties' adherence to contract obligations and addressing improper interference by other institutions must be a priority. The system cannot work without an operational model that both establishes and enforces agreed upon rules and regulations and contractual terms that are binding on both institutions and student athletes. We continue to review facts as they unfold in this matter, and we will evaluate all options going forward to determine the appropriate course of action. To help me navigate through all of the legal complexities, I'm so happy we can be joined here on Locked On Canes by Darren Heitner, who we've referenced a number of times the past few days here on Locked On Canes. He is an attorney representing Xavier Lucas, and in all of this, we refer to it as a saga. It's been going on for over a month, and we appreciate everything Darren is doing for Lucas and all the insight. And the truth teller, Bruce Warner, keeps coming out of retirement. He's back. I know he's got some legal questions. Bruce is an attorney, by the way, but let's start out here with Darren. So, Darren, we read the statement from Wisconsin for all of the people out there, and I'm sure you're very anxious to give Xavier's side and your side on this, since Wisconsin clearly gave their side of it. Let's start with what the Badgers what they repeatedly referred to as a binding 2-year contract that was signed by Xavier Lucas. How can a revenue sharing contract, how can that be binding, even though the House settlement can't pass for about another 2.5, 3 months?
Excellent question, Alex. First of all, thanks so much for having me. And I've been following your coverage. It's been excellent. It's probably been pretty difficult to follow because everything's moving so quickly.
Mhm.
To your question specifically about the Memorandum of Understanding, which purports to be 2 years in length, and how it can be reconciled with this House settlement that is preliminarily approved by Judge Claudia Wilkin, a federal judge, but it will not be finally approved until the earliest April 7, 2025. That is the date on which she has decided to host a hearing. And at that hearing, she can provide final approval. She can rule from the bench and do so. She can also take it under advisement and decide to rule at a later date. Or she can say, I have a lot of concerns with this settlement agreement. I am not going to provide final approval. We go back some months when there was a hearing for preliminary approval. She actually expressed a lot of concerns about how the settlement agreement was worded. Ultimately, the parties, that being the counsel for the plaintiffs as well as counsel for the NCAA, went back to the drawing board, made some minor adjustments, and Judge Wilkin decided to ultimately provide that preliminary approval. A lot of people, including schools, conferences, and the NCAA, appear to be operating as though it's a shoo-in that Judge Wilkin will provide final approval and that she will do so on or around April 7, 2025. From my perspective, it's not a guarantee. But I think what's of penultimate importance is that when we look at these contracts that are being signed, and if we look at Wisconsin and some other Big Ten schools that have decided to essentially adopt this Big Ten template, and by the way, that is the reason why the Big Ten issued a statement in support of Wisconsin, because it is the architect of the agreement that Wisconsin and some other Big Ten schools, not all Big Ten schools, are using. It is premised on this final approval of the settlement. But as we sit here right now having this conversation, the NCAA rules are what the NCAA rules are, which is that there cannot be pay for play. Schools cannot make direct payments to players. The state of Wisconsin, unlike a couple of other states, has not modified its laws either through legislative work or an executive order to allow for direct payments from schools to players. And Wisconsin didn't pay Xavier Lucas. So the fact of the matter is, as drafted, at least from my perspective, the contract's not valid and binding because it relies on certain premises that have not yet occurred. And by the way, there's no damage to Wisconsin because it hasn't actually paid out any money to Xavier Lucas at this point in time and never will. Mm-hmm. So to me, this is not a battle that Wisconsin wants to take. It's hard for me to speculate as to what it will do. I was surprised by the fact that it issued a public statement. I think a lot of people were surprised by it. Less surprised that the Big Ten decided to follow Wisconsin's statement and provide support. That was not at all surprising to me.
You know, Darren, you said something about an agreement or the contract. It seems like it was drafted by Wisconsin and the Big Ten with no input from anybody else. I'm concerned about that. I mean, how do you have an agreement if two parties don't agree to the language in the document? So these guys are being forced to sign these things, it seems like.
Bruce, in our profession, we oftentimes refer to that as a contract of adhesion. And if the terms are so one-sided, and one of the parties, the athlete, who may not have had representation review the contract, didn't have a real appreciation for what he was signing, and really all the rights are provided to the other side. Mm-hmm. From my perspective, it's also an illusory contract.
Correct. That's what I meant.
And could be unconscionable. So
absolutely,
that goes beyond the myriad of points that I know, Darren.
But
because it is, deep into the law, and on X it's a bit tough to go that deep and have a real appreciation, and then I'm just going to get thousands of responses from these angry Wisconsin fans. And by the way, they're hitting up my Instagram and sending me DMs, and unfortunately
They love
sometimes
me
going
too, don't
into
worry.
religion. Yeah, it is what it is. But yes, Bruce, you're preaching to the choir there, and I think it's just one more reason why it would be so short-sighted for Wisconsin and the Big Ten to escalate this, because if you put it in front of a judge who appreciates the law, this is the type of contract that can get struck down. And I didn't negotiate this contract for Xavier Lucas, but I have negotiated this MOU on behalf of other players at other Big Ten schools. There's not a single one that we just executed upon delivery. There was a lot of blood on that paper, which means a lot of redlining, right? And so, yeah, I think there's a big risk, because if we go to court on the validity of the contract and a judge deems it to be invalid and not enforceable, what does that mean for all the other contracts that have been executed thus far?
Right.
Well, we got some more questions here for Darren Heitner, founder of Heitner Legal. He represents Xavier Lucas, and I also want to kind of get Darren's insight on how that whole process went down. The loophole that they found to get Lucas out of Wisconsin and to Miami legally by NCAA rules, despite never actually entering the portal. Happy to have the truth teller with us as well, because I need, when it comes to this much legal stuff, I need two lawyers. Just me and one lawyer is not enough here. You guys want to keep it locked. We're only getting started on this brand new episode of Locked On Canes. Guys, I'm so happy that Prize Picks is with us here on the Locked On Podcast Network. I've been playing Prize Picks since 2021. Folks, Prize Picks is the place to get real money sports action. With over 10 million members and billions in winnings, Prize Picks has changed the game in daily fantasy sports. Whether it's the playoffs or regular season, Prize Picks has made it easier than ever to win big while enjoying all the football action. Now it's playoff time. There's no better way to get in than with Prize Picks. Here's how it works. You simply select more or less on at least two players, more or less than their stat projections. And if your picks hit, you could win up to 1,000 times your cash. That's right, 1,000 times your money just by making a few simple picks. Guys, it takes me under 60 seconds to make my selection, select between 2 to 6 players, and you can go cross-league and cross-sport. You can have NBA players, NFL, college football players, hockey, right on the same selection, folks. Ready to run your game this football season? Download the app today and use code LOCKEDONCollege to get $50 instantly after you play your first $5 lineup. That's right, $50 just for playing. Download the Prize Picks app. Don't wait. Take your game to the next level with Prize Picks. Run your game. We're also proudly brought to you by FanDuel. FanDuel is the perfect companion for Prize Picks on game day. You've got game night tonight in the college football playoff. I like Ohio State to win and cover. I think they're probably going to pull away late. And you can get all of that action on FanDuel. From the first whistle to the final drive, FanDuel makes the NFL playoffs even more exciting. Right now, new customers can bet $5 and get $300 in bonus bets if you win your first bet. That's $300 to keep the action going. The FanDuel app is so easy to navigate, and the variety of bets keeps every game exciting. Plus, when you win, you get paid instantly. No waiting around for your winnings. Whether you're betting on your favorite team or just looking to add some extra excitement to the playoffs, FanDuel has you covered. Guys, you can get bets on which player will score a touchdown, over-unders on player props, over-unders on scoring totals. Just visit FanDuel.com to join today and get started with $300 in bonus bets. That's FanDuel.com. Make this playoff season unforgettable with FanDuel, an official sportsbook partner of the NFL. Thank you so much for making Locked On Canes your first listen and your first watch today. We're free wherever you get your podcasts. We're free on YouTube. We're part of the Locked On Podcast Network, your team every day. So, Darren, something that grabbed a lot of people's attention from the Wisconsin statement was claiming that they have what they referred to as credible information. That was the term, not credible evidence, but credible information about Miami allegedly tampering with Lucas. To your knowledge, do they have something, or do you have any idea what they think they have?
To my knowledge, the answer is no. I have not spoken with Wisconsin in a few days as we're recording this podcast. I only had a small amount of communication with Wisconsin leading up to Xavier deciding to unenroll from the university and then subsequently enroll at the University of Miami. I had made numerous efforts to communicate with the school, was very frustrated in that process, but ultimately did connect with somebody who absolutely has authority to speak on behalf of the University of Wisconsin. I don't want to get too deep into those conversations because we agreed to keep it as settlement-related conversations and keep those communications privileged. But one thing that I did discover in those communications was that, at least as far as I understood, they didn't have real proof other than hearsay as to whether or not there was tampering. And in the limited amount of time that I've been part of Xavier's team and as his counsel, I have not personally seen or heard any examples of tampering by the university. In fact, it appears that the university was very, very careful to not go down that path. And we were also careful in terms of how we orchestrated this whole process within the scope of the NCAA's rules. I mean, as I'm sure you and your listeners saw, the NCAA released one of the most interesting statements it has ever issued, at least as long as I've been living, which is that it says there's nothing that we did that is impermissible, that you can actually move schools outside of the transfer portal, largely rendering the portal useless. One thing that does remain, and I do want to clarify because there's a lot of speculation surrounding this point, an athlete still can't transfer from one school to another and play within that same season for the new school. That is still a rule.
Yeah.
And the NCAA has not changed that rule, and I don't see the NCAA changing that rule anytime soon, unless, of course, there may be a legal challenge surrounding that. But going back to your question, again, we unenrolled from Wisconsin. We decided to enroll at the University of Miami, and there was no tampering in terms of that process. I personally wasn't involved with Xavier Lucas prior to being officially retained. I can't speak for what did or didn't happen prior to that. I just haven't seen any evidence that supports that there was tampering. And until I see that, how can I believe it?
Here's my question, because I asked Alex before we went on. What's your definition or legal definition of the word tampering? Can you explain that to the fans? That's a good question, Darren.
It's a really good question. And when I hear the word tampering, I typically believe that is within the confines of an employer-employee relationship. And what's so interesting about that is not only has the NCAA and all of its member institutions fought so hard for so many years to avoid such a classification, but within the MOU itself, and I'm saying this because there's actually a Sportico piece that was recently published that cites to this specific item, the universities go to a very far extent to basically have the player contract away the theory that there is employment. Like, they are resisting this concept of employment, yet at the same time, allegedly, we know they're using the word tampering and alleging that tampering occurred. From where I sit, I'm very familiar with a cause of action, tortious interference with contractual relations, or tortious interference with an advantageous business relationship. Again, it's a state-by-state specific inquiry. And typically, this falls within the scope of employment relations, which have been resisted here. And there's a number of different factors that need to be proven. I've litigated it on the plaintiff and the defense side many times before. It's one of the harder causes of action to prevail on. You have to show that the other side had actual knowledge of the specific agreement, had an intent to interfere with that agreement, and that interference led to damages based on the individual deciding to leave one place for another. Again, it would surprise me for Wisconsin to desire to escalate, not only to sue a player, which I think in and of itself is such a bad look, But to escalate it without having all the necessary evidence there, I think it's opening up.
They're just going by an appearance of impropriety, is what it seems like to me. They're just it's when you said third parties, that's like hearsay. I don't know how they're going to get past all that.
That's my impression as well. We live in a world where, whether we like it or not, social media is so important. It gives everybody a voice. I think what you have to do as a responsible person is separate those voices that are credible from just those that are taking up space. And if Wisconsin is relying upon all the social media chatter from Joe Schmo in the middle of nowhere of Wisconsin, that's scary. Now, if they have credible evidence, they have credible evidence. But I haven't seen it. And, one thing I'll say, I don't represent the University of Miami. I wouldn't represent the University of Miami if this does get escalated. So from my personal standpoint in representing Xavier Lucas, it's irrelevant to the whole conversation. But at the same time, it's something I've been interested in exploring. And as I said before, I haven't seen any evidence of tampering.
Okay. Well, that's their whole basis, apparently.
Yeah.
Well, that's their claim supposedly against Miami, should they decide to escalate. Again, to me, that would be a tortious interference claim, which is very difficult to prevail on. I think they're trying also at the same time to raise the red flag to the NCAA and say, hey, you need to do something about this and investigate the University of Miami. But again, I think it's super dangerous in terms of the course that they're going on, because at the same time that they're asking this or claiming that there was tampering, they're also in their statement admitting to an overt violation of NCAA bylaws. So the NCAA, from my perspective, has no choice but to enforce its bylaws and punish Wisconsin for just ignoring the bylaw. It sets a very terrible precedent.
And what you're talking about is that their obligation to enter his name into the portal within 48 hours. That's what you're referring to?
Yes, and some people have mistaken this as mere guidance. No, it's an NCAA bylaw, and it specifically states that when a player decides to enter his name into the transfer portal, the institution has 2 business days to do so. And Wisconsin didn't do that. And there's no contractual basis to avoid the obligation of complying with the NCAA bylaws. The bylaws don't provide an exception for Wisconsin to avoid its obligation of putting his name in. And in Wisconsin's statement, it admitted to the fact that it didn't abide by that bylaw. So now the NCAA has a very important decision to make. It has to, and from my perspective, punish Wisconsin for violating that bylaw. Because if it doesn't, then what prevents any other school from doing the same exact thing?
That's what I said.
Now, maybe it's inconsequential because we found a workaround from the transfer portal as a whole. That said, it's still important to provide that opportunity for players to go through the transfer portal, because by doing so, this whole concept of schools contacting a player, that's allowed once a player is in the transfer portal. It's still not allowed if the player simply unenrolls and then decides that he wants to go elsewhere. During that gap before he applies for admission at that new school, the schools can't have direct contact with the player. So there are still benefits related to going through the transfer portal process. The other thing that's scary for the NCAA is if the NCAA takes the position that because this MOU was in place, Wisconsin didn't have to put Xavier's name in the transfer portal. Now what the NCAA is saying is the bylaws mean absolutely nothing because you can contract around them, which is wild.
Right. Yeah.
What happens hypothetically if Xavier said, I'm going to take a trip down to Miami by myself. I'm still enrolled in Wisconsin, although I've asked to be put into the portal. And he comes down here just to say hello and visit or whatever. I mean, it could be construed as tampering because he might be here, but can a player do that, or he can't even visit other schools?
Yeah, technically he cannot have contact. Well, the school can't have contact with him. It's a school related bylaw. It's not Xavier who would have any consequence that results from it. It's the school that could be punished by the NCAA if it has communication with a player outside of the portal. But your scenario is almost exactly what happened here, absent the communication, right? Xavier came down to South Florida. I think one part of this whole story that really is not being focused on enough, and to an extent, I appreciate it because it's personal, but Xavier came down and found a sick father and said, you know what, I really want to be close to home. And, that's another part of this whole story that, as I mentioned, isn't really getting publicized. But if Wisconsin and or the Big Ten were to escalate this, it would become a very important part of all of it. And I think just further negatively impacts their reputations, because here's a player who really wanted to be close to home because he has an ailing father and grew up down here. Obviously, coming out of high school, from my understanding, it was really between Wisconsin and Miami. So it's not as though he's unfamiliar with the university, and decided, look, I want to be close to home. This is a school I want to play for. So, yeah, I signed this MOU. In a very short amount of time thereafter, decided, it's best for me to be close to home, so I'm close to family. You guys haven't paid me anything. There's no detriment to you. Let me go into the portal as I have the right to do under the NCAA bylaws. And that's why even before I was officially retained by Xavier, I was speaking quite publicly on the matter, because I couldn't quite comprehend, and still can't to this day, why Wisconsin has taken this approach. I think it will have long-lasting impacts on Wisconsin. Look, I don't get joy out of it. I just think that's the reality. If you're a player, do you really want to go play for a school that takes that type of position?
They can forget about recruiting South Florida kids. That's for sure. Right, Alex? We've talked about that. They can forget.
At least not for a while. But it's something I'd like to know from Darren. Of course, once you joined Lucas's legal team, you were able to ultimately, as we've talked about on Locked On Canes, you were able to find that loophole actually around the transfer portal, because Wisconsin never put him into it. Was that sort of viewed as a last resort? Did you expect a different sort of resolution? How did that process play out for you guys?
I wouldn't say it was a last resort. I would say it's something that we discovered as we went through the process of seeking any potential solution short of litigation.
Right.
So I wish I was hired right around the time that Wisconsin decided to not put his name in the portal, and right around the time that Xavier fired off that tweet that got millions of views and basically put all this into motion. I understand that he may have hired other counsel and it wasn't fruitful, it didn't amount to much. And so, I was retained, I guess, as we're talking now, a little bit less than, I think, 2 weeks ago. So I didn't have a lot of time. Plus, I was under the gun, right? I mean, I'm hired, and he obviously can't go back to Wisconsin because bridges were burned. Like, how can you go back to an institution that is overtly threatening you and where you've made it very clear you don't want to play? It would be quite awkward. So we're sort of in this position of purgatory where we feel as though, and all signs show, we have to go through the portal, but Wisconsin's not putting our name in the portal. And so I did a few things. I started drafting a complaint. I actually finished, I think, roughly a 30-page complaint, and was in the process of finalizing a motion for temporary restraining order and preliminary injunction. For those of you who don't really know what that is, if you're familiar with the Diego Pavia situation at Vanderbilt, when he filed a lawsuit for an extra year of eligibility, he also filed that type of motion, and the judge granted it, giving him an extra year of eligibility while the case plays out. So that's sort of what I was attempting to do, which was file a lawsuit against Wisconsin and the NCAA, but concurrently filing a motion to allow him to at least enter into the portal and go to a school of his choice. At the same time, I was trying desperately to reach out to somebody with authority at Wisconsin, and was frustrated, very frustrated in that process. And then nonstop communicating with the NCAA, with the legal department there, to see if there was any way that we could get this done peacefully without escalation of litigation. I understood that the NCAA's position was, we have rules, we need to enforce our rules, but we do so by punishing institutions that violate the rules. We can't force a school to put a player's name into the portal, which frustrated me, but I also understood it. And I just started combing through the bylaws and asking a lot of questions, and ultimately determining and speaking with the legal department at the NCAA that there was a workaround, which was unenrolling and deciding to apply for admission at another university. And look, I wasn't willing to embark on that path until I had complete certainty that this could not negatively affect Xavier's eligibility. And so that also took some time to just make sure that I had that comfort. But we were on the 1 yard line of filing a lawsuit. Like, we were about to file, which I know there's been a lot of media attention and scrutiny based on what's happened even in lieu of litigation. Litigation would have been nuclear war. And I honestly think, and this may come in the future, I think that the type of lawsuit that we were going to file under antitrust law could have actually abolished the transfer portal as a whole, ultimately. And maybe that's where this all goes anyway. It's just now delayed. But we were pointing or taking direct aim at the transfer portal based on what transpired here. This is a restraint of trade. This is Wisconsin saying, you are our indentured servant. I mean, there's no other way of putting it. Like, you're trapped.
Yep. Sometimes this is like a game of chicken. You've got two sides, and the lawsuit, as an attorney, the lawsuit puts the other side on notice. Hey, you want to fool around? Let's go. You have such a downside for this. Are you sure you want to do this? Why don't you just give up, punt, and let the kid go to wherever he wants to go? I'm not saying Miami, because I don't want to say that that's where he was definitely going, but still, I think sometimes you have to do that. Now, you were right on. Fortunately, you got it resolved before that, but still.
In my own personal interests, if this was ego-driven, I would have filed a lawsuit. I would have loved nothing more.
Right.
Putting the client's interests first, I think the right move was to find a creative solution.
Of course.
And, if we had to sue another day, we'll sue another day. If we have to defend against a lawsuit from Wisconsin and or the Big Ten, we will, and we'll probably file counterclaims. I hope it doesn't go there. I don't think it's a smart move by them.
What would they get out of it, Darren? What's the upside for them?
Well,
he's enrolled in Miami now, or is he still in limbo?
No, he's enrolled.
Okay.
I don't know yet whether he's been reclassified to spring as we speak right now, as we're recording this podcast. I know he has been admitted for the fall. Okay. With the intention that we will get him reclassified for the spring, and that he'll be on campus in the very near future.
Admitted for the fall, meaning he can't play in spring practice?
Unless
he's he's reclassified, which we expect. It may happen before you air this podcast, right? So, but it was really interesting. Right when we were about to file was when the NCAA annual convention was starting. And I heard from various journalists, it was all anyone could talk about, which was, holy crap, this is going to get filed. Like, we don't want it to get filed, but we also really at the NCAA level can't do much to prevent it or anything, because we can't. Yeah. We would love Wisconsin to put his name in the portal, but we can't coerce them or force them to do so. So basically, there was a desire that this all, gets resolved, which from our perspective, it has been. Why would Wisconsin and or the Big Ten decide to now escalate this? I would ask the same question. Why didn't they just put him in the portal when I got involved and ask them very politely to do so? Why did they issue a statement, which I thought was, it's funny. Wisconsin fans are like, well, why are you criticizing them, Darren, for putting out a statement? You were begging them to say something. Well, sure, I gave them bait, but I didn't think they'd take it. I mean, like, come on, that was idiotic. So I've said this a few times now. Like, if you trust that an institution the size of Wisconsin or a conference the size of the Big Ten is operating on logic, you wouldn't have expected them to do those things, or you would have expected them to put Xavier in the portal and not issue the statements that they did. So when I'm asked, do you expect litigation? Again, a rational actor wouldn't, but I don't know what they're thinking. And I guess a justification for doing so is they're now really concerned that people won't treat these contracts as valid and binding, and they need a decision that says that they are. And maybe if they sue in a friendly jurisdiction, they'll get a judge, who is looking to help out Wisconsin or the Big Ten, and will deem that there's been a breach. But again, even if you go down that path, what are the damages? I still can't comprehend
What's the
that.
downside? What's the damage? To me, it's incredible. If they were
And
smart,
how long
they
does
would
this get
save
drawn out
faces and
for?
shut up already. They would say, we were wrong. We apologize. Let the kid have a good time in Miami and move on, because they've created more than just a mess with one player, I think. I wouldn't be surprised if more players want to get out of there now.
You guys know the media cycle now more than ever before. If they stop talking about it, obviously they put out their statements. If they stop talking about it, if they don't escalate it, within a week, no one's talking about this anymore.
Right.
And no one's going to care if I have anything to say about it. And by the way, I probably won't have much to say about it anymore either. Like, I did not expect those statements. I didn't. I'm actually wearing a Panthers shirt now. I was at a Panthers game on, what was it? It was Saturday night. And I think it was 8 p.m. Eastern, right around that time that the statements were issued. And everyone's begging for a response. And I'm out there with my kids and my wife enjoying the game. Go Panthers, by the way, 3-0 win over the Ducks, our best team in South Florida. But yeah, it's like, holy moly. Like, as I said before, they took the bait, and now, I'll respond in kind. And I think that's only led to more attention over the weekend, now dripping into this week, where it probably, if they didn't issue those statements, people wouldn't even be talking about it anymore. And there really wouldn't be any.
I know I wouldn't be. Yeah. No, honestly, I thought, because I had done an episode about Lucas either, Friday or Saturday morning, whenever it was. I think it was Friday. And Friday night, I thought, okay, all right, we're going to move on. And then the Wisconsin statement comes out. I had to reach out to Darren. So yeah, that's where we're at. Well, I appreciate both of you taking the time. The truth teller, this has been the shortest retirement on record. You keep I love it. I keep inviting you back. You keep coming back. Darren Heitner, founder of Heitner Legal. Darren, we appreciate you taking the time. We appreciate the clarity, because again, a lot of people are talking about this without legal knowledge and without knowledge of the situation like you have. So you weighing in on it here on Locked On Canes means everything. And thank you so much for doing that.
Yeah, thanks, Darren.
Yeah, thanks so much for having me.
You're down here. You're down here, Darren. You're down here in South Florida.
Yeah, I'm actually teaching my NIL course at Law this week, so we have a little bit to talk about.
All right, you do.
Yeah, great meeting you. I appreciate your insight to all this. It's all about the U, baby.
That is.
I'll be silent on that one.
Yeah.
Where'd you go to school? Where'd you go to school?
I went to University of Florida, undergrad in law, so I'm just going to be quiet.
Jeez.
Well, we love you anyway. We appreciate everyone for taking the time, and we'll talk to you again next time on another episode of Locked On Canes. We are part of the awesome Locked On Podcast Network, your team every day.